Yeah, sir. Thank you.
Yeah. Comrades, in this channel, more than 100 people have joined, and we have also given the live to our other channel. So some are there also. And some people are not having that Zoom app, so they are searching. But because Sar is there, we will start. And already Comrade Mehta, Comrade Shankar, they are all there. Partho is also there. So we shall start the meeting. Comrade Rajan Nagar is finding it difficult to join. He will join shortly. I would ask Comrade Rambabu to formally welcome, because with his help only we could fix up Professor Sir. So Rambabu,
yeah,
welcome.
yeah. Comrades, today you are all aware that the labor codes have already been adopted and the notification has already been issued. So the whole country is now rather very anxious to know what exactly the implications of the newly adopted labor codes. So we have requested Sri DIVAKAR BABU. He is the principal of SIDARTH Law College, Vijayawada. So he is very close to us. Many a times he spared his time and he addressed on several matters on all of us. So he has kindly, when we requested, he has agreed also to address all of us. So suddenly this meeting has been arranged. He has got authority over the newly adopted codes also. So on various occasions he was addressing also. So sir, Professor DIVAKAR BABU garu, we welcome you. So you are very well aware of the present situation. The entire bank employees community, apart from along with other workers in this country, would like to know what exactly the provisions in the 4 labor codes and what are the implications of these codes. Because earlier the Indian Trade Union Act 1926 and the Industrial Dispute Act 1947 were almost catering to the needs of most of the workers in the country, including the bank employees. But how these newly adopted codes are really hampering the interests of the bank employees, that we would like to know. So we welcome you, Sri DIVAKAR BABU garu. I request you to now address the gathering.
Namaste, comrades. Thank you for giving me wonderful opportunity to share some of the ideas and critical comments on these 4 labor enactments. Before going into these 4 labor codes, let us have a conceptual clarity about how the labor jurisprudence has evolved over the last 150 years after the Industrial Revolution. The history of labor movement is full of many examples that capital has never yielded to the demands of the labor unless and until the labor has united and organized into trade unions and agitated for a long period of time. So at the beginning, the working conditions were so horrible, lengthy, and just like inhuman conditions prevailed. So the working conditions stretched beyond 18 hours, and some of the workers died while working, and there was nothing like social security, and there was nothing like welfare. So in this context, the ideas of socialism have spread throughout the nook and corner of the world. The workers began to organize into trade unions, and the workers at the beginning demanded the limited working hours, humane working conditions with welfare and social security. Because of the relentless struggles of the working class, because of the relentless struggles of the working class, the then capitalist class had realized that unless and until the working conditions were reduced and they were made relatively human, then it is not possible to continue their exploitation. And in this process, the courts have also intervened by taking the grassroots reality of the agitating workers, and courts have also come out with certain new principles of industrial jurisprudence. So the point which I would like you to understand is that the industrial jurisprudence did not come out of vacuum. The industrial jurisprudence encompassing the limited working hours, 8 hours of working day, leave, rest days, social security, all these labor benevolent legislations have come only when the workers have agitated and they carried out relentless struggles. So because of this, we have so many benevolent and social welfare legislations. For example, the acts like Trade Unions Act, the Industrial Disputes Act, and the Industrial Standing Orders Act 1946. And we have so many legislations. All these legislations recognize to a certain extent the rights of the workers. But now, the central government, without any consultation with the trade unions and the other stakeholders, had enacted 4 draconian laws. And these laws include Code on Wages 2019, Code on Industrial Relations 2020, Code on Occupational Safety, Health and Working Conditions, Code on Social Security. And the central government has stated that these enactments would come into force on November 21st. But rules have been drafted, but rules are yet to be notified. Once the rules are notified and they are published in the official gazette, then these 4 enactments along with the rules would come into force at the same time or concurrently. And the central government has created a very rosy picture about these 4 enactments, saying these 4 enactments would create a level playing field between the capitalists and the working class. And these 4 enactments are like a bonanza to the working class. And because of these 4 enactments, the workers, both in the organized and unorganized sector, would get fair wages. And an ideal level playing field has been created between the employers and the employees. And these 4 enactments, according to central government, are landmark legislations which aim at creating a conducive, peaceful and friendly labor relations. Is it true? Whether all these proclamations made by the central government are realistic, or is there any hyperbole in them? The answer is, all these 4 labor enactments are highly regressive, retrograde, and they strike at the rights of the working class. And in fact, these 4 labor codes are regressive for the reason these labor codes aim to take away the right to strike and the security of the employment and other welfare conditions of the working class. So now let us discuss these enactments one by one. The first one is Code on Wages. So before we delve into Code on Wages, we should go back to past in order to see how are the wages and what are the laws relating to wages. This Code on Wages repeals 4 existing labor enactments, namely the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and Equal Remuneration Act. So these 4 enactments presently regulate the payment of wages, including the payment of equal wages to men and women and the payment of bonus. So these 4 enactments are repealed, and in their place code on wages was brought into force. So this code on wages says that the floor wage would be fixed by the central government, and no state government can fix the minimum wage below the floor wage. That is what this code on wages says. Therefore, the central government was proudly proclaiming that this code on wages fixes the floor wage, and no state government can fix minimum wages below the floor wage. But the funny and fanciful thing about this code on wages is that the floor wages fixed by the central government was a pittance. It was only 173 rupees per day. So imagine, for the sake of for the sake of argumentation, the wage that was fixed by the central government as floor wage at 173 rupees, will it be sufficient to cater to the needs of a single individual, let alone leave the whole family? So that is one thing. And the other important thing is, under the existing Payment of Wages Act and Minimum Wages Act, the wages would be revised for every 3 years. But the code on wages says that after the implementation of this act, the wages would be revised for every 5 years. That means the wages are not linked with the price, the cost of price index. So there is a data given by the IMF, World Bank, and even the international organizations. All this data clearly says that the wages of the executives of the companies are increasing by 200-fold and 300, more than 200 and 300-fold. But at the same time, the wages of the workers, the wages of the employees have increased by a nominal ratio of 0.2 to 3. And in most of the cases, the wages of the workers have become almost stagnant. So in such a scenario, so when wages of the employees are not increased, then there will definitely be a slack in the demand, and as a result of which there will be lesser consumption. All this affects the economy in total. It would have a spiraling effect on the economy. But in spite of this, so there is a linkage between the increasing of the wages of the employees and the overall recovery of the economy. Because when wages of the employees are increased, then it would definitely reflect in the enhancing of the demand, and as a result of which consumption would also be increased, and it would give a spur to the economic revival. But in spite of this, the wages, the code on wages aims at fixing the floor wage at a minimum rate. It says that once the central government fixes the floor wage, then no state government can fix the minimum wage below the floor wage. And the other important thing is that minimum wages shall be fixed based on the skill of the employees and depending on the region. That means the minimum wages to be fixed by the state government may vary from region to region and from state to state. So in such a scenario, there is every possibility that some state government may fix the minimum wages at the lowest level in the name of attracting the foreign direct investment or the indigenous capital, and consequently the workers would be the worst sufferers in this case. We are already seeing that almost all the BJP state governments have revised their labor laws. Friends, labor welfare, labor codes as a subject occurs in the concurrent list of the Indian Constitution. According to 7th schedule of the Indian Constitution, the labor codes subject occurs in the concurrent list. That means, as per the scheme of the Constitution, both the central government and state government can make the laws. So by using this flexibility, almost all the BJP state governments have amended the labor laws so as to increase the working hours to 13 to 14 hours, and further to reduce, in some cases even to reduce the rate of wages, and in some other cases by imposing a capping or a ceiling on wage hikes. So this would create a kind of unjustified competition among the states to fix wages at the lowest level under the garb of attracting foreign direct investment and indigenous capital. There is always a danger in that. And apart from this, the wages on code says that previously, under the existing laws like Minimum Wages Act, Payment of Bonus Act, the Equal Remuneration Act, we have inspectorate mechanism. But these laws say, this code on wages says, now onwards, the inspectors would be known as inspectors cum facilitators, and their prosecutory powers would be abolished, and they would act as advisors and facilitators, and for the certain contraventions. And previously, if non-payment of wage, if wages were not paid properly or on time, then they were treated as criminal offenses. But now the code on wages says that any violation of law would not be treated as a criminal offense, and they would be treated as compoundable offenses. Compoundable offenses means that you can pay the fine and you can escape yourself from the punishment. And even the fines have been reduced. So the Modi government has stated that the purpose of these 4 codes was to create ease of doing business, so that to reduce compliance burden on the employers, so that the Indian industry could effectively compete with the multinational companies. But the problem here is that by reducing the compliance burden on the employers, the government has given carte blanche. The government has given enormous power to the employers to contravene these provisions, so that they can violate as many provisions as they could, but they could escape from the prosecution by simply paying the fine. So the code on wages is indisputably a retrograde legislation for the reason that it fixes the floor wage at a minimum rate, and it provides for the revision of the wages only after 5 years instead of 3 years as mandated by the present law. And apart from this, it says that the inspectorate mechanism would act as merely as facilitator and advisor, even in the case of contravention of the provisions of these code on wages. So in such a case, the employers could easily escape from the punishment, provided they are ready to pay the penalty. So that is, and even the penalties that are existing under the present laws have been drastically reduced. In some cases, for example, where under the present law, when the offense committed is non-payment of wages, then penalty could be around, the penalty has been reduced to 50%. In other cases, where the offense involves not only the criminal but also civil, the penalty has been reduced to 75%. So from this, what we can understand is the code on wages is not only regressive but also retrograde, because it doesn't address the ensuring of fair wage to the employees. What is fair wage? So under the Minimum Wages Act, similarly under the Payment of Wages Act, the courts have evolved in industrial jurisprudence where it was clearly stated that the profits of an industry is generated by the combined effort of capital and the labor. The capitalist might invest his capital, but labor has invested its blood and sweat. So, unless and until the sweat and blood of the labor joins with the capital, profitability would not be generated. That is the reason as to why the Supreme Court has emphatically held that if the profits of an industry reach a certain level, then a fair wage should be paid to the employees instead of the living wage. Fair wage means a fair wage is a wage which not only takes care of the minimum requirements of the employees, it also assures minimum comforts, minimum luxury to the employees. But the Code on Wages has not recognized the concept of fair wage. So that is the reason as to why one could definitely say that Code on Wages is highly regressive and retrograde. Now let us see the Industrial Relations Code. Of all these four codes, the Industrial Relations Code 2000 is the most regressive, draconian, and retrograde in nature. Why? The reason is, so previously, if an employer of an establishment employing 100 or more workmen or employees decides to lay off or lock out or retrench or close that industrial establishment, then the employer must invariably obtain prior permission from the appropriate government before invoking the layoff, lockout, retrenchment, or closure. For example, where in an industrial establishment 100 or more workers or employees are employed, and if the employer of that establishment intends to lay off or lock out or retrench workmen or close the industrial establishment, then that is not possible unless and until the employer obtains prior permission from the appropriate government. So now this Industrial Relations Code 2020 says that the limit of 100 workers or 100 employees has been enhanced to 300. That means the employers of an industrial establishment employing less than 300 can close the industrial establishment, can lay off the workmen, can lock out the workmen, can retrench the workmen without any permission from the appropriate government. So if 300 or more employees are employed in an industrial establishment, then only the employer of such an industrial establishment need to obtain prior approval from the appropriate government before effecting layoff, lockout, retrenchment, closure. That means most of the industrial, almost 90% of the industrial establishments in India are employing less than 300 workers. That means 90% of the industrial establishments are exempt from taking prior approval from the appropriate government before planning to do layoff, lockout, retrenchment, or closure. That means the regulatory mechanism hitherto existing in the form of a control over the employees of an industrial establishment in laying off, locking out, retrenching, or closing the industrial establishment has almost, not fully, has almost abolished. So therefore, as I've already said, once again, I would like to emphasize emphatically, 90% of the total industrial establishment in India are employing less than 300 workers or employees. Therefore, this 90% of the industrial establishments are exempt from taking prior approval from the appropriate government before effecting layoff, lockout, retrenchment, and closure. That is one thing. And the other important thing is that previously there is some kind of differential treatment in regard to the strike between public sector establishments and non-public sector establishments. A non-public sector establishment the employees of a non-sector public sector establishment or employees of non-public utility can resort to strike without giving any notice. Why? No employees of a public utility service can resort to strike unless and until a 14 days notice is given. But now the Code on Industrial Relations says whether it is a public sector undertaking or whether it is a public utility service or non-public utility service, both of them would be regulated by the same provision. It says employees of any establishment, whether it is a public utility service or non-public utility service, cannot resort to strike unless and until 14 days notice, 14 days strike notice is given. That means the right to strike has been subject to the condition as to giving of mandatory notice, not only in regard to public utility service, but also in regard to non-public utility service. That means if the employees of a public utility service or a non-public utility service decide to go on strike, then 14 days notice strike, 14 days strike notice should be given, and strike should not be commenced within 14 days. And after these 14 days, when cancellation proceedings are initiated, then strike should not be resorted to during the cancellation period. And after the cancellation, if adjudication is started, then again the strike should not be resorted to. That means stringent restrictions on the right to strike of workers and employees has been imposed. Friends, right to strike is an effective tool of collective bargaining. The Supreme Court of India has said in plethora of cases that the right to lockout is available to employers, and as a countervailing force, right to strike is available to the workers. So therefore, right of strike is antithetical to right to lockout available to the employers. So the Supreme Court has described right of strike is an important weapon of collective bargaining. But unfortunately, this Code on Industrial Relations says that no strike shall be resorted to, or no strike shall be done by the workers of either a public utility service or a non-public utility service without giving 14 days notice. And even after the period of 14 days notice, if cancellation proceedings commence, no strike shall be resorted to. And the other important thing is the definition of strike has been expanded by saying if more than 50% of the employees in an organization or establishment go on mass casual leave, then it amounts to strike. So the very definition of strike has been artificially expanded by saying when more than 50% of the employees or workers in an establishment go on mass casual leave by way of protest or otherwise, then it would be treated as a strike. Treated as a strike. Friends, there was a time when the Supreme Court of India had emphatically stated that when the strike is legal and justified, then the employees are entitled to claim wages for the period of strike. According to the Supreme Court, a legal strike was defined as a strike which was done in pursuance of the legal provisions embodied in the Industrial Disputes Act. A justified strike is a strike in respect of which the demands were quite reasonable, just, fair, and legitimate. So if the strike was legal and justified, then workers are definitely entitled to full wages during the period of strike. That is what Justice Krishna Iyer has stated in so many cases. But subsequently, what happened? In India, the trade union movement got weakened, and because of this liberalization, privatization, and globalization policies of the government, the media was totally under the corporate control, and because of all this, the voice of the trade unions was not properly heard, and therefore the Supreme Court had also deviated from the earlier decisions by saying, even if the strike was legal and justified, yet the workers were not entitled to get wages for the strike period because of application of no work and no pay. No work and no pay. So the point which I would like you to understand is, note carefully, judges are not immune from the happenings taking place in the society. If the trade union movement is very strong, and workers and employees are able to raise their voice loud and heard by all the sections of the society, then definitely court would also be influenced by that. So the change of this concept of legal and legitimate, legal and justified strike to no work, no pay was possible only because of the weakening of the trade union movement in India, apart from the policies of the liberalization, globalization, and privatization, and the corporate control of media. That one should understand. And apart from this, the Code on Wages says that for registration of a trade union, previously under the Trade Unions Act 1926, any 7 members can register a trade union. But now it says that a trade union can be registered only by 100 persons or 1/10 of the total members working in that industry, whichever is less. So that means that when this Code on Industrial Relations comes into force, then the registration of trade unions becomes cumbersome, difficult, and intricate. Why? Because for registration of trade union, 100 members or 1/10 of the total members, whichever is less, is necessary. And even after the making of the application, if half of the members withdraw from their signature, then the application will not be cancelled. Even after the trade union was registered, even after the registration of the trade union, if minimum requirement necessary for registration were withdrawn, then also the trade union would be cancelled. The registration of the trade union would be withdrawn by giving a notice. Then what does it indicate? It creates a kind of fear atmosphere in the minds of the trade unions. So a trade union could function effectively only when it has the legitimate power and capacity building to work and espouse for the cause of the workers. So it says that even after the registration of the trade union, if the minimum strength that is to be there for registration goes below that, then it can be cancelled. That means you all know pretty well how the executive works according to the whims and fancies of the political bosses. So, for example, in India, the rule of law is like a farce, though all are equal before law and equal protection of laws. But that is not the case at the ground level. The ground level reality is something different. So consequently, what will happen would be the trade unions which were not to the liking of the government, the trade unions which were not pliant to the management, would face the backlash from the government, and in such a case, the government may exert pressure on the trade union registration officers to cancel registrations to the independent trade unions. There is every such possibility. And the other important thing is, it says that in the case of industrial establishments, a trade union having 51% of the votes, or a trade union having 51% of the total membership, would be recognized as a sole negotiating union. That means if a trade union is having 51% of the total votes or 51% of the total membership, then it would be recognized as a sole negotiating union. That means if the other trade union, though having 49% or 48%, then it would be excluded, and the sole recognized, the sole negotiating trade union alone would be competent to enter into agreements with the employer. So that is what the Code on Industrial Relations says. That means, so any trade union having 51% of the total votes or 51% of the total membership would be recognized as a sole negotiating trade union, and it alone would be empowered and competent to enter into agreements with the employers, and the other trade unions having having 49% of the voting power or 49% of the membership would be excluded from the process of collective bargaining. From the process of collective bargaining, as a result of which what happens would be, even the workers who are ideologically committed to the other trade unions would be compelled and coerced to join into sole negotiating trade union, and this provision would be beneficial to the management in the form of curbing the plurality of the trade unions. So the Modi government was very fancy about one nation, one election, one nation, one tax. So it would also result to one industrial establishment and one trade union. So there is a lurking danger in this. So this provision strikes at the plurality of the trade unions subscribing different ideologies. BJP has its own trade union, BMS, Bharatiya Mazdoor Sangh. Similarly, many parties have their own trade union, but this provision aims at curbing the multiplicity of the trade unions working in an industrial establishment by promoting singularity of the trade union. So there is a lurking danger in it that one should take care of it. And apart from this, it says where in an industrial establishment there is no trade union having 51% of the voting power or 51% of the total membership, then a trade union council of the negotiating trade union council would be established, and even in negotiating trade union council, a trade union would be eligible to join in it only when it has a minimum of 20% of the voting power or 20% of the total membership in that establishment. And the other important thing is how this would be determined. Only rules would say. So rules are yet to be notified. So you know pretty well this government has the draconian and draconian history of formulating the rules in a non-transparent manner, and even the rules formulated were quite arbitrary, whimsical, capricious, unilateral, abrasive. So there is every possibility these rules would be formulated in such a manner so as to favor to the hand-picked trade unions or trade unions which are pliable or servile to the interests of the government. The reason being, you know, at the beginning, the Bharatiya Mazdoor Sangh had opposed these 4 laws, saying that these laws were anti-labor. But now the BMS has come out with a pliant view saying, okay, if some of the provisions are modified, then these laws would be definitely welcomable. So that is how they change their colors like chameleon. So about which we should be very, very cautious and wary of it. And the other important thing is the Code on Industrial Relations says that industrial establishment having less than 300 workers need not formulate standing orders. So we have presently an act by name, Industrial Employment Standing Orders Act 1946. Industrial Employment Standing Orders Act 1946. What this act says? This act says that every establishment employing 100 or more employees must prepare a industrial employment standing order, and it should be prominently displayed. The standing orders designed, formulated, adopted, and put into force by every industrial establishment would contain the rights and obligations of the employees and the employers, like what is the total working hours per day, what is the rest day, and what are the wages that are to be payable for the overtime. So, and similarly, so all these entitlements would be vividly described in the standing orders. So, for what rights the workers are entitled to, and what are the obligations of the employers, and what are the obligations of the employees. So, industrial standing order is like a mutual contract, is like a mutual agreement between the workers and employers, defining their rights and obligations in a comprehensive manner. And under the present act, every industrial establishment employing 100 or more workers must formulate, design, adopt, and implement standing orders. But now the Code on Industrial Relations says that industrial establishment employing less than 300 need not formulate standing orders. And even for the industrial establishments employing 300 and more, they need not prepare standing orders. If they adopt the model standing orders, that would be sufficient. That would be sufficient. That is what the code says. And the other important provisions include, it says that the government has proclaimed, the government is proudly proclaiming with much pomposity that the Industrial Relations Code provides for time-bound adjudication. Time-bound adjudication. Any labor case would be decided within 1 year, but here we should read in between the lines. Here there is a tricky situation. The tricky is, under the present labor codes, industrial tribunal consists of only judicial members. But this code says every industrial tribunal would comprise of 2 members. One is a judicial member and one is an executive member. One is executive. Executive member means the IAS, IPS, and other bureaucrats, IRS officers who have retired from their services could also be appointed as the members of the industrial tribunals. You know how executive in India has been gradually degenerating, and they have become almost the survival agents of the political bosses, political executive. So if persons of executive background were appointed as the members of the industrial tribunals, one could definitely expect about the poor quality of the adjudication mechanism. In such a case, there is every possibility that these executive authorities may bend to the pressure of the political bosses and thereby give their findings, conclusions in favor of the management. So that is most worrisome thing in the Industrial Relations Code. So from this, what we can understand is the Industrial Relations Code has almost taken away the right to strike of the employees, and the Industrial Relations Code has almost taken away the right of collective bargaining of the employees, and this code has further taken away the security and protection of employment. You may ask how. So as I already said previously, if 100 or more employees or workers are employed in an industrial establishment, then the employer of such an establishment, before invoking layoff, lockout, retrenchment, closure, cannot do it unless and until approval of the appropriate government is taken. But now the employer of industrial establishments employing 300 or more workers or employees only need to take the permission if industrial establishments employing less than 300 could easily hire and fire their employees. So that means the Industrial Relations Code has conferred an unfettered right of, almost an unfettered, uncontrolled, unbridled right of hire and fire on the employers, How? That means if an industrial establishment less than 300 workers are employed, then the employer of such an industrial establishment has an unlimited right not only to hire but also to fire his workers. So consequently, we are going back to the concept of laissez-faire state instead of welfare state. What is the concept of laissez-faire state? The concept of laissez-faire state was based under the notion that employers and employees have equal bargaining power. So, if employers and employees enter into an agreement, and if those agreement contained certain conditions, those conditions were prima facie unfair, unjust, unreasonable, unconsignable, arbitrary, nevertheless, they were valid. That was how the laissez-faire state argued. But after India attained independence, after India attained independence and it adopted the constitution containing certain egalitarian principles, and the constitution has clearly recognized the employers and employees had no parity of bargaining power. The employer had more bargaining power while the employees have lesser bargaining power. So therefore, if the employer, by using his dominant bargaining power, exploits the employees and thereby inserts any unreasonable, unfair, unjust condition in the contract, then that condition is not valid. That is what the Supreme Court has said in Central Inland Water Transport Corporation versus Brijunath Ganguly. But now the Modi government is turning the clock back to the laissez-faire state, by saying that any unconsignable, unreasonable, arbitrary, ridiculous condition in a contract of employment would be valid, like what we have seen. So 90% of the industrial establishments in India employ less than 300 employees. So all these 90% of industrial establishments were given an unlimited power of hire and fire. That we should understand. And the other important thing is, the Industrial Relations Code also aims at weakening the trade unions. How? It tries to weaken the trade unions, as we have already seen. Only a trade union having 51% of the total voting power or 51% of the total voting power would be recognized as a sole negotiating trade union, and it alone would be allowed to enter into agreements with the employers. The rest of the trade unions would almost be ignored. Consequently, what will happen? The members of the remaining trade unions would be subject to enormous pressure to leave those trade unions and get into the majority trade union, enjoying the support of the management. As a result of which, what would happen is that it would lead to one industrial establishment and one union, like one nation, one tax, one nation, one identity card. So it will lead to such a situation. And apart from this, as we have already discussed, the quality of adjudicatory mechanism has been weakened. How? It says that the labor tribunals would consist of a judicial officer and an executive officer. Who are these executive officers? Retired bureaucrats. These retired bureaucrats, after their retirement, would be enjoying these positions only on the condition that they should serve the interests of the government. Consequently, to expect impartial and objective justice from these industrial tribunals would become an illusion. So that also one should take into consideration. And apart from this, the shocking thing about these new labor codes is it recognizes the concept of limited period of employment. What is the limited period of employment? In US, we have seen how the Trump has come out with the same notion, saying that he has almost terminated more than 1 lakh federal employees, almost 1 lakh federal employees, saying that these federal employees are a burden on the state, and because of which how the welfare system has been adversely affected, we are seeing. Similarly, the Modi government has come out with limited period employment. What is this limited period employment? All these codes, whether it is code on wages, code on industrial relations, code on social security, code on occupational safety, health and working conditions, recognize limited period employment. But even this limited period employment, which is the most draconian provision, is propagated as a bonanza to the working class, saying that even if an employee has worked for 2 years, he would be paid gratuity, provident fund, pension on par with that of the permanent employees. So Modi government is pro-labor. It has done many benefits to the working class. But for understanding this, we should read in between lines. We should go to the root of the problem. So the government wanted to legitimize the limited period employment. So therefore it says that any person who has completed 1 year of continuous service is eligible to claim gratuity, pension. But note, my dear friends, that gratuity or pension or provident fund that will be payable to limited period employees would be proportionate. This is very important. Would be proportionate to their period of employment. That means if an employee has rendered 10 years of service, then he will be getting a gratuity of 1 lakh. But an employee has rendered only 1 year of continuous service, he will be getting a gratuity of 10,000. You see the variance. So there is nothing beneficial or benevolent to the working people or to the employees. That you should understand. So this limited period employment is very dangerous. So when more and more industrial establishments, even public sector, so it would be implemented in the private sector, and subsequently it will spread to public sector undertakings like the banking sector, insurance sector. So in limited period employment, there is always a danger. The danger is if employment is only for a period of 1 year, then on the head of the employee, there is a Damocles sword. And this sword always gives a warning to the employee. If you participate in trade union activity, if you are not servile to the management, your limited period of employment will not be extended beyond 1 year or 2 years. Consequently, it weakens the trade union movement. It prevents the employees or workers from taking membership in the trade unions. And apart from this, it makes the workers docile, servile to the management. So the rights which the right of fixed, the right of secure and protective employment achieved by the working class after relentless struggles is sought to be defeated by this limited period employment. So Agniveer, we have seen Agniveer. Modi government has come out with an Agniveer scheme of 5-year limited employment in armed forces. Now, this Agniveer scheme has been indirectly introduced, in these 4 labor codes by a different name. There, Agniveer, here, limited period employment. So, even this limited period employment is propagated as something beneficial to the working class by saying that even an employee having 1 year of continuous service would be paid gratuity and other social security benefits. But those social security benefits that are allowed, that are paid to the limited liability employees is proportionate to his period of employment. So it doesn't render any benefit to the employees. That we should keep in mind. So limited liability employment or limited period employment is the most draconian provision, because it takes away the right of secure employment, which is an essential element of the labor jurisprudence and even recognized by the International Labour Organization. So if working class allows this limited period employment, then there is every possibility this limited period employment would become dominant over the secure employment in the days to come. So this should be fought tooth and nail to protect the security of employment. And apart from this, take the case of the Supreme Court in many cases has said that the right to strike is a weapon available to the workers, as a right to lockout is a weapon available to the employers or management. So right to strike is antithetical, means opposite to the right to lockout. That is what the Supreme Court said. But the point which I would like to pose, before you is, all these labor codes have imposed many restrictions, many unreasonable restrictions on the right of the workers and employees to go on strike. But is there any limitation on the right to lockout? The answer is a loud no. Instead, the right to lockout available to the management was strengthened substantially by saying that any employer of an industrial establishment employing less than 300 employees or workers can freely resort to lockout. So the previous restriction of 100 has been enhanced to 300. So you see the Modi government class interest in this. So whom does the Modi government wants to serve? It wants to serve the big industry at the cost of the working class. That one should. So this government has brought about these enactments for the benefit of the management, to legitimize the ruthless exploitation, suppression, depression, and compression of the working classes. So, but unfortunately, the media is painting, portraying, depicting all these laws as bonanza for the working class, but the reality is something different. That one should keep in mind. And the other important things are Code on Social Security. So, in Code of Social Security, it is like a mixed bag. There are some provisions which are beneficial to the working class. And the maternity leave has been enhanced from 12 to 26 weeks. And similarly, even for an employee who has rendered 1 year of continuous service, will be given gratuity. And it further says that social security benefits should not, the wage component should not be, the wage component should be minimum of 50%, and the remaining incentives like overtime allowance, housing should form only 50% by imposing a capping on those things, so that the minimum wage could be 50%, so that the social security benefits would be more. But the thing is, but the point here we need to ponder over is, when the floor wage that was fixed is a pittance, is meager, is unreasonable, then the question of workers getting benefit doesn't arise. So in India, more than 90% of the workers are from the unorganized sector. So for them, the floor wage that was fixed was very grossly unreasonable. So if that is the thing, then the question of benefiting them doesn't arise. And it is true that organized sector could gain some benefit, but here again, I have a definite feeling that these social security benefits were like a bait thrown before the employees. It is a bait because so it is a bait for them to accept limited period employment. Okay, suppose previously the Gratuity Act says that no employer can claim gratuity unless and until he has put in 5 years of continuous service. 5 years of continuous service. Suppose if limited period employment comes, then workers would definitely say, so if limited period of employment is less than 5 years, then what about gratuity? So to legitimize and legalize the limited period employment, these social security benefits have been nominally subject to some kind of embellishment like rolled gold. So therefore, there is whatever is there, it is only ostentatious or ornamental. So the government main objective in introducing this payment of gratuity after 1 year and enhancing maternity leave from 12 weeks to 26, and ESI benefit, Employees State Insurance Corporation benefit to every employee, whether organized or unorganized, is only ostentatious. Even now, if you take the Employees State Insurance Corporation benefits, has the government improved the infrastructure facilities? Has the government improved the number of ESI hospitals? Has the government improved the number of ESI dispensaries? What are the total funds allocated by the government for improving the infrastructure facilities of the Employees State Insurance Corporation? The resources over the years is gradually reducing. Please try to understand. So this government is known for jumlas. Okay. So you may wonder if I say, in the year 2014, the contribution of the manufacturing sector to the gross domestic product, to the GDP, was 17%. Please remember, this is not my data. This is the data given by the government of India only. In 2014, the contribution of the manufacturing sector to the GDP was 17%. The Modi government has come out with a very fanciful, captivating scheme, Atmanirbhar Bharat, Make in India. So after these 10 years of Make in India scheme, the contribution of manufacturing sector to the GDP is merely 13%. That means 13%, 4% has been reduced. Where is the impact of Make in India scheme? Where is the impact of Atmanirbhar scheme? So please ponder over these vital facts. So this government indulges in blatant lies. So please try to understand. So all these are lies. So some benefits have been given under the Social Security Act to the working class, but these benefits are ostentatious. They are like embellishments, and they do not touch the root of the problem. So therefore, whatever benefits have been created are merely nominal. And the next one is Code on Occupational Safety, Health and Working Conditions. So these Code on Occupational Safety, Health and Working Conditions shall apply only to those industrial establishments employing 10 or more. So in India, most of the establishments are small, micro and medium enterprises employing less than 10. To them, this protection is not given. And however, it says that these benefits, but apart from this, the working conditions, here again, the management was given flexibility to enhance the working conditions from 8 to 12.5 weeks, 8 to 12.5 hours, 8 to 12.5 hours. So the managements have been given the flexibility to enhance these working hours from 8 to 12.5 hours by fixing some rest hours. And the Modi government says that women have been empowered because women have been allowed to work even during the night shifts. So now, because of this new codes, women can be employed from 6 p.m. to 7 a.m. So they can be employed even during the night time. Yes, they can be employed during the night time. So it is definitely treating men and women equal. But what about the conditions of the work? So if you see the data of the government, the accidents at the workplace are going up instead of going down. Has the government addressed that issue? So when the working conditions have not been, when the conditions of work at the workplace have not been improved, then increasing employment of women at the workplace, you can understand and predict the consequences. Apart from this, so code on occupational safety, health, and working conditions can be better enforced and implemented by strengthening the inspectorate mechanism. But what does this code says? This code says that now onwards, the inspectors would be known as inspectors cum facilitators. Inspectors cum facilitators. The power of prosecution that has been vested with the inspectors has been taken away, and they are merely treated as facilitators and advisors. Consequently, almost all minor offenses were abolished. So previously, for certain minor offenses, the punishment was 6 months, ranging from 6 months to 1 year. So all those punishments were abolished, and in their place, those offenses will be treated as merely contraventions, and for which the employer or the management would pay the penalty and easily escape from the prosecution. Even the penalty that has been there thus far has been reduced, in some cases to 50% and in some cases to 75%. So if that is the case, there is a saying on the state of Indian law. The saying is that Indian laws mostly bark and they rarely bait. Indian laws mostly bark and they rarely bait. So if this inspectorate mechanism is made more weakened, feeble, emaciated, you yourself can predict the outcome. So these provisions would remain only on the statute book without proper implementation, and consequently, whatever benefits are envisaged under this occupational safety, health, and working conditions would not reach to the working class because of taking away of the powers of prosecution available to the inspectorate mechanism, by treating them as mere inspectors cum facilitators. And so this is the most worrisome feature in the occupational safety, health, and working conditions. Apart from this, and almost all micro, medium enterprises have been excluded from the coverage. But in spite of this, the government says gig workers, platform workers, and unorganized workers have been covered under various schemes of under various schemes of these acts. So they were covered, but in regard to platform workers, gig workers, are they treated as regular employees? The answer is no. The government merely says a welfare board will be established, and because of that welfare board, many benefits will be given to the gig and platform workers. Is it true? Then what is the contribution of the employer? So what is the contribution of the government to this welfare board? Only if the rules are published, one could know about the same. And apart from this, this code on occupational safety, health, and working conditions, as I've already said, and once again I would like to emphasize emphatically, aims to enhance the working conditions by providing working hours, by providing rest hours in between up to 12 and a half hours, 14 hours, and the BJP ruled states and some of the states ruled by the Congress are making competition in this respect, and they are enhancing the working hours in the name of attracting foreign direct investment. But unfortunately, in India, if you see the government data, even the foreign direct investment is gradually getting down instead of going up. Going up. You must have seen the latest IMF report. As per the latest IMF report, that the foreign direct investment is gradually getting down. Is gradually getting down. Why? Where is the problem? So the problem is, in India, most of the consumers have less purchasing power. As I already said, world over, the salaries and wages of the top executives are going up by 200% and 300%, while the salaries of workers and employees have either become stagnant or increased by less than 1%, mostly between 0.2 to 0.5. So consequently, when people have less purchasing power, the demand will also be slack. So when slack demand is sustained by lesser purchasing power, would any investor, whether foreigner or domestic investor, would dare to invest? The answer is a loud no. A loud no. And apart from this, after the Modi government came to power, the high net worth Indians are leaving this country in increasing number. This data is not provided by me. This data is also provided by the government of India. Why this is so? These are the things which we need to ponder. So in conclusion, what I would like to say is that these 4 labor codes, code on wages, code on industrial relations, code on occupational safety, health and working conditions, code on social security, though propagated as bonanza, beneficial and benevolent for the working class, in fact, these 4 codes take away the entrenched rights of the working class that have won due to their relentless struggles. And especially, these codes weaken the very concept of collective bargaining. These codes almost dilute the right of strike of the working class. These codes strengthen the principle of hire and fire. These codes aim to legitimize the limited period employment. Apart from this, these codes facilitate ease of doing business by giving bonanza, by giving unlimited power to the managements. And apart from this, these codes disturb the existing industrial relations between the workers and employers by giving enormous power to the employers. So therefore, these codes are indisputably against the interests of the working class, So in these 4 codes, at the same time, I candidly agree, there are some provisions which are beneficial, but they are like a bait thrown before the working class. How it is like a bait? See, these are the beneficial things. So if you accept these beneficial things which are so nominal, then you have to accept the rest of the provisions. Okay? But when you evaluate these provisions on pros and cons, definitely these codes have more baneful effects rather than beneficial effects. So the working class should build a network with the farmers and other stakeholders to fight against these codes. And we have the glorious history of we have the glorious past history of the farmers' struggles, how farmers have opposed the 3 draconian laws, and they fought tooth and nail by carrying out a long agitation, and subsequently they won their rights. And similarly, the working class should build a network with other suffering masses like farmers, and micro and owners of micro medium enterprises, because they are also affected by the government policies, so as to oppose these codes, so that the the entrenched rights which the working class has won due to their relentless strikes should be should be restored as it is, without any erosion, because some of the provisions of these codes are even in violation of the ILO conventions, to which the government of India is a signatory. That also we should take notice of. So in toto, what I would like to conclude is that these codes are not these codes overall are not beneficial to the working class, and apart from this, these codes erode and strike at the very root of the industrial jurisprudence that has been evolved over a period of more than 70 years in this country, due to the long struggles of the working class. So we should definitely agitate over these codes in order to protect the entrenched rights of the working class. If you have any doubts, queries, definitely we will discuss. Thank you for giving me this opportunity, for sharing some of my ideas in this course. And I'm very much confused the way the print media, the print and electronic media is depicting these codes as something bonanza by painting a rosy picture. And they say that these codes are a win-win situation, but in reality, these codes are not win-win situation. It is a win for the management and lose for the working class. So, which we should take into account. Ramapur over, and if any queries, then definitely I will definitely answer them.
No, sir. I think we have the discussion again, once again, when you are free, after our people go through. Today it was very enlightening, very educative, very informative. People have got overall this one. We will also tell them to go through all these things. It was very nice that you could spend time and in a very simple way. All these myth that is being created, that they are all wonderful, beneficial to the workers, all those things you have explained very nicely. We shall further discuss among ourselves. And I already talked to Comrade Rambabu that we will have further interaction with you as at the apex level, our leadership level, our central committee office bearers would like to meet you. We'll invite you. At that time, we can have more. In the meantime, we feel that the trade unions are going to meet on the 14th, and then programs will come, and very rightly you said, along with the farmers, etc. There, All India Bank Employees Association, we shall be there. As you said, that some provisions are little beneficial. I may also inform you that in banks, we are the majority. So that way, a few things are there. We will further discuss with you. We want to thank you. And I'm very happy, Comrade Rajan Nagar, our president, he has also joined just now. So I would request him to conclude this webinar. Comrade Rajan, are you available?
Yeah.
Yeah, you can conclude.
You are hearing me?
Yeah, we are hearing you. You can conclude.
I joined from the beginning.
Okay, right.
I thank Professor DIVAKAR BABU for giving us insight in a very simple manner. It has enhanced our. I am thankful to DIVAKAR BABU,
Okay.
who has given a very nice insight of the 4 labor codes.
Thank you, sir.
And it is true that these labor codes are not for workers, rather our established rights, which we achieved through various struggle, has been taken away. So all-out fight, united fight will be required and we must fight it. Laborers are worst sufferer of the neoliberal economic policy. And in banking industry also, these labor codes will create havoc, and we will prepare ourselves to fight it out. There is no alternative. And as my General Secretary has said, we may require again to study the things with your help, and which will be available, I believe. And again, I thank you very much for giving your precious time and putting the things in a most simple manner so that we can understand. Those
Thank
who
you.
have
Thank you.
followed this talk, they will be benefited. From myself, I will say that I am benefited, and we are fighting. And as a working class, I believe that there is no alternative to to all these attacks. Only to fight on the streets, fight with unitedly with working class, and that we shall do. Thank you very much. Good night to everyone, and especially to Professor DIVAKAR BABU.
Thank you. Thank you for your nice words. Thank you. Katem.
Hello.
Uh-huh.
Yeah. So we can conclude now, and
Yeah.
I would also thank Comrade Rambabu for arranging this precious time of professor, and I thank all our office bearers, central committee members, general council members, even our other activists. And this lecture has been also made live in our other channels also, so it will be there. We shall again further discuss. I also join our president in thanking Professor DIVAKAR BABU. We know him because I have already met him in Vijayawada a number of times. And with this, once again, thanks to all of you. We conclude this.